So, what happens when a country's own domestic law seems to completely contradict an international treaty it signed? Well, we're about to find out because this isn't just some classroom hypothetical. Nope. This is the story of a really high stakes legal showdown between the United States and the United Nations, playing out right in the middle of New York City.
And it all kind of comes to a head with this one single document. This is a letter from the U.S. Attorney General back in 1988. And what it's doing, essentially, is handing the Palestine Liberation Organization's UN mission its eviction notice. With this one piece of paper, the U.S. wasn't just trying to shut down an office. It was about to kick off an international legal firestorm.
All right, so how did we even get here? Well, the root of this entire mess was a direct clash, a head-on collision, really, between a brand new American law and a treaty that had been on the books for decades.
Okay, so the whole conflict really boils down to these two documents. On one side, you've got this new U.S. Anti-Terrorism Act, which sets, loud and clear, that the PLO office has to close. But then, bumping right up against it is the 1947 UN Headquarters Agreement. You know, the treaty that lets the UN even be in New York in the first place. And that treaty guarantees access for all UN invitees. So, which one wins? Does the host country's new law get to just override a promise it made 40 years ago?
Now, you might think a situation like this would just be total legal chaos, but the people who drafted that 1947 treaty were actually pretty smart about it. They built a specific rulebook, a clear procedure, right into the agreement for how to handle this exact kind of dispute. And right at the heart of that rulebook is this process called arbitration. The easiest way to think about it is like calling in a neutral referee to settle a fight. Both sides get to present their case to an impartial panel, and whatever that panel decides, well, that decision is final and binding on everybody. And you can really see just how serious they were if you look at the exact words they used in Section 21. It doesn't say disputes may be referred or should be referred. No. It says they shall be referred for final decision. And, in the world of law, that one word changes everything. Shall isn't a suggestion. It's a command. So, okay, you've got a clear conflict and you've got a clear rule book for how to solve it. This should be pretty straightforward, right? Well, not so fast. This is where things took a sharp turn and escalated into a full-blown diplomatic standoff. Things just escalated incredibly fast. The U.S. law gets passed in December. By January, the UN Secretary General says, okay, a dispute officially exists, and he triggers the arbitration process, just like the rulebook says. But then, bam, roadblock. In February, the U.S. just comes out and says it's not willing to participate. By March, with the treaty's own rules being ignored, the UN realized it had to escalate this even further. So this is the UN, legally speaking, putting its foot down. The Secretary General is following the procedure to the letter. He's formally declaring a dispute, and he's invoking the exact process they both agreed to 40 years earlier. It's a total by-the-book move. And here is the U.S. response, which is just fascinating. They don't even try to argue that a dispute doesn't exist. Instead, they just say that arbitration would not serve a useful purpose. It's a very diplomatic way of saying, yeah, we're not going to do that, which completely sidesteps their mandatory treaty obligation and creates this total impasse. Okay, so the U.S. is refusing to follow the rulebook. The UN plays its final card. It takes the whole issue to the highest judicial body on the entire planet, the International Court of Justice, the World Court. And they asked for what's called an advisory opinion, which is basically asking the court for an official, authoritative ruling on a very specific question. And the question they asked was just surgically precise. They didn't ask if the new U.S. law was okay. They just asked this. Based on everything that's happened, is the United States required, by the treaty it signed, to enter into arbitration? That was it. That was the only thing the court had to decide. So the stage was set at The Hague. Both the UN and the U.S. submitted all their arguments, and now the world's top international judges had to make the call.
And the result was honestly just stunning in its clarity. It was a 15-0 vote. Every single judge, and this includes the American judge on the court, every single one of them agreed. A complete and total consensus.
So what was their unanimous opinion? A clear and simple yes. The United States of America is under an obligation to enter into arbitration. The language was just so direct, there was absolutely no room for misinterpretation. The treaty meant exactly what it said. So how did 15 judges all come to the same conclusion? Well, their logic was pretty much airtight. First step, the totally opposing positions of the UN and the US clearly created a dispute. That's a fact. Step 2, that dispute was undeniably about how to apply the headquarters agreement. And finally, step 3, since negotiations had failed, that mandatory arbitration clause had to kick in. See, just a simple logical progression.
Now, this whole ruling was about so much more than just one office building in New York. The court's opinion really echoed through the halls of international law, and it reinforced a principle that basically holds the entire system together. And here it is. This is the bedrock principle at the very heart of the case. The court pointed to what it called the fundamental principle that international law prevailed over domestic law. Or, to put it simply, a country can't just pass one of its own laws to get out of an international promise it already made.
So what's the lasting impact of all this? Well, it sent a really clear message. Promises matter. A country can't just use its own internal politics as an excuse to ignore its international obligations. This ruling hammered home the idea that the rulebook for settling disputes is just as binding as the treaty itself. And maybe most importantly, it showed that the international legal system actually has teeth, even when it's facing off against a superpower. Ultimately, this case perfectly captures a tension that is still very much alive today, and it leaves us with a really critical question. When a country's internal politics clash with its international legal commitments, which one should be the one to give way?